Hello friends, I hope you are doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today, we will discuss the provisions of Foreign Marriage Act, which deal with the marriages of citizens of India outside India. Now let's start with an introduction first. Marriage is a common tradition not only in India but all over the world. And we are all accustomed to the values of this tradition that hold the culture and the family values together. The value of marriage lies in both religious and non-religious societies across the world. They follow the custom of marriage, representing a civilized society of beings. The sanctioned union between two people would greatly enhance the development and welfare of the people. The Foreign Marriage Act bridges the gap between Indian citizens and foreigners by providing a common platform for the solemnization of marriages. The objective of this act is to solemnize the marriage between Indian citizens and foreigners. There are various pre-existing marriage laws in our country, but this act covers the exclusive and exhaustive conditions or various possibilities that can be related to marriage. In other words, they have some special provisions related to marriage that are not mentioned impliedly in other acts related to personal laws. This act bridges the gap between the Indian marriage laws and the foreign marriage laws and has some exclusive provisions for citizens as well as non-citizens. In India, such marriage laws are governed under the Foreign Marriage Act 1969. The importance of Foreign Marriage Act 1969 we will be discussing now. So moving further, we will discuss that how this act plays a very important role as it is a foundational law for the issue related to foreign marriages. India is culturally diversified and tradition-enriched country where marriage is considered a holy union. The Act provides recognition of marriage irrespective of any tradition, custom or unreasonable conditions. The Foreign Marriage Act is completely based on factual situations. In addition to certain fulfillment of conditions that are justifiable as to recognize the marriage according to the laws of the country. The Act recognizes the presence of a couple and their consent in which one should strictly be an Indian citizen, as mentioned in Section 4 of Chapter 2 of the Act. Section 4 states certain conditions relating to solemnization of marriage. This Act has eliminated many flaws that would have created issues and dilemmas amongst the public. Previously, there were no dedicated marriage laws for foreign nationals or Indian marriages in foreign countries. The Act has also reduced the conflict over certain issues relating to marriage recognition. So, for example, in the judgment delivered by the Bombay High Court, Minoti Anand and another versus Subhash Anand and others, in 2011, the court held that the marriage was solemnized under Section 18 of the Foreign Marriage Act. The fact was that they were an Indian Hindu couple and the marriage between them was performed in Japan as per the Japanese traditions and customs. It was registered under the Foreign Marriage Act. The major dispute was about the claim of matrimonial relief, and the parties were at odds that it should come under the Hindu Marriage Act 1955. but the court held that since the marriage is solemnized under the Foreign Marriage Act, the special relief would be claimed under the Special Marriage Act of 1954. Section 18, subsection 1 of Chapter 4 accepts the provisions of chapters 4 to 7 of the Special Marriage Act 1954, and it shall be applied in the case of parties whose marriage was solemnized in foreign countries between parties, and one should be a citizen of India. In another landmark judgment of the Andhra Pradesh High Court in relation to Section 18, Joyce Somati versus Robert Dixon Brody, in 1982, the court held that if the parties marry in a foreign country, then relief can be claimed under Section 18 of the Foreign Marriage Act. The fact is that the wife of the appellant is a resident of India and they reside in Bahrain. As per the facts, the husband deserted the wife and so wife filed for divorce in the lower court of India. The lower court dismissed the petition on the ground that marriage is not registered under Section 17 of the Foreign Marriage Act. But after the appeal in the High Court, it was concluded that marriage solemnized under Section 18 of the Act or any other marriage solemnized in a foreign country should be taken into consideration as a valid marriage, on the condition that one party should be an Indian citizen. And so, the wife's petition to move forward for divorce was held maintainable. Under Section 17, Chapter 3, the solemnization of marriage is the process of performing the official marriage ceremony. The solemnization of marriages require an exhaustive process. The provisions of the Act are as follows. Where a marriage officer is satisfied that the marriage has been duly solemnized in a foreign country in accordance with the law of that country between parties of whom one at least was a citizen of India, and a party to the marriage informs the marriage officer in writing that he or she desires the marriage to be registered under this section, the marriage officer may, upon payment of the prescribed fee, register the marriage. So further, no marriage shall be registered under this section unless at the time of registration it satisfies the conditions mentioned in Section 4. The marriage officer may, for reasons to be recorded in writing, refuse to register a marriage under this section on the ground that in his opinion the marriage is inconsistent with international law or the Committee of Nations. Where a marriage officer refuses to register a marriage under this section, the party applying for registration may appeal to the central government in the prescribed manner within a period of 30 days from the date of such refusal, and the marriage officer shall act in accordance with the decision of the central government on such appeal. Registration of marriage under this section shall be effected by the marriage officer entering a certificate of the marriage in the prescribed form and in the prescribed manner in the marriage certificate book, and certificate shall be signed by the parties to the marriage and by 3 witnesses. Marriage between a Muslim husband and a Hindu wife taking place in a foreign land cannot be put to an end by a Muslim husband by the pronouncement of talaq, even though he may establish that he had, after coming to India, entered into matrimony as provided in Muslim law. As decided in the case of Abdur Rahim Undre versus Padma Abdur Rahim Undre in the year 1981. Further, Section 18, Clause 3A, Subclause 2 of the Foreign Marriage Act requires that the petitioners have been residing in India continuously for a period of 3 years, immediately preceding the presentation of petition, as decided in the case of Maria Linda Rodericks versus Ashley Joseph Rodericks in the year 1992. Further, let's now discuss the conditions relating to solemnization of foreign marriage under Section 4 of the Act. So, as per Section 4, marriage between parties can only be possible when one of the parties is a citizen of India. Otherwise, the marriage will not be considered under this Act. Secondly, the parties should not have any existing spouses or pre-existing marriages. They shouldn't have any living spouses, as this has been specifically mentioned under Section 4, Clause A of the Act. Under this Act, the condition of monogamy is required for registration. Thirdly, at the time of marriage, both parties should be of sound mind. This essential condition mentioned under Section 4 Clause B is the mental condition of the parties, which should be stable. They shouldn't be idiot or lunatics at the time of marriage. Fourthly, this condition under Section 4 Clause C discusses the age of parties eligible for marriage solemnization. At the time of registration, the bridegroom must have completed the minimum age of 21 years, and the bride must have completed a minimum age of 18 years. The violation of minimum age would render the marriage null and void. Moving further, Section 4 Clause D specifically states that parties shouldn't be within the degree of prohibited relationship. If the personal law or custom is binding on any of the parties, and even if that law or custom permits the marriage, and the marriage is solemnized, then the marriage will also come under the degree of prohibited relationship. As per Section 11 of the Act, marriage should not be in contravention of the local laws. The marriage officer can refuse to solemnize the marriage by stating justifiable reasons that have been recorded in writing. Marriage should not be prohibited by law in force in a foreign country where it has to be solemnized. The marriage officer has to state the reasons in writing to refuse the solemnization of marriage if he thinks that marriage is inconsistent with international law. The section also mentions the remedial measures under subclause 3 for the issues related to solemnization of marriage by the marriage officer. If the marriage officer refuses to solemnize the marriage, then the intended party may appeal to the central government as per the rules within a period of 30 days. So after that, the marriage officer has to act as per the decision given by the central government. When a marriage has to be solemnized under the Act, then the parties must give prior notice in writing for their intended marriage to the marriage officer of the district, in which at least one of the parties to the marriage has resided for a period of not less than 30 days, immediately preceding the date on which such notice is given, as mentioned under Section 5 of the Act. The form structure should be in accordance with the first schedule of the Act. It will be counted after the notice is given and the party has resided. Lastly, as per Section 12 of the Act, which states the conditions for declaration by parties and witnesses. So there should be at least 3 witnesses and 2 parties. they should sign the declaration in the form that is specified in the second schedule in the presence of the marriage officer, and the declaration shall be countersigned by the marriage officer. So next is, after the conditions are met, the solemnization of marriage is the next phase. So when notice is issued of the intended marriage, the marriage officer has to maintain the marriage notice book specified under Section 6. The Act stated that the marriage officer should keep a record of all the notices given under Section 5 of the Act. A true copy of every notice should be entered in the book that is prescribed for that purpose, and it shall be called the marriage notice book. The book can be inspected by any desirable person free of charge, and it shall be open for inspection at all reasonable times. The marriage officer shall publish the notice given under Section 5 of the Act. This has been mentioned under Section 7 of the Act. The notice shall be published in his own office by affixing the copy at the prominent place, as well as in the foreign countries where the parties are ordinarily resident in the prescribed manner. So moving further, let's now discuss the next process after the publication of the notice, which is to invite objections to marriage under Section 8 of the Act. So Section 8 of the Act invites objections to marriage by any person within 30 days from the date of publication of notice in the public domain. The notice that is issued under Section 7 of the Act can be objected to under the following specified conditions that are stated in Section 4 of the Act. So the objection shall be in writing, along with the signature of the person or any other person authorized on his behalf or her behalf. The person objecting should also specify the ground of objection, and the marriage officer shall take note of the nature of the objection in his marriage notice book as well. If no objection is made within the 30-day period specified in Section 8 to an intended marriage, then on the expiration of that period, the marriage may be solemnized. When the objection is raised under Section 8 of the Act, the marriage officer cannot solemnize the marriage until the objection is resolved. If the objection is raised, then there is a procedure for receiving the objection given in Section 10 of the Act. The marriage officer will inquire about the matter of objection. So moving further, Section 13 provides for the place and form of solemnization of marriage. Marriage by or before a marriage officer under this Act shall be solemnized at the official house of the marriage officer with open doors between the prescribed hours in the presence of at least 3 witnesses. The marriage may be solemnized in any form which the parties may choose to adopt. However, it shall not be complete and binding on the parties unless each party declares it to other in the presence of the marriage officer and the 3 witnesses, and in any language understood by the parties. Also, where the declaration referred to in the preceding proviso is made in any language that is not understood by the marriage officer or by any of the witnesses, either of the parties shall interpret or cause to be interpreted the declaration in the language that the marriage officer, or as the case may be, such witnesses understands. So further, after the declaration of marriage, a certificate of marriage is issued under Section 14 of the Act. the marriage officer shall enter a certificate that is specified in the third schedule in the marriage certificate book that should be kept by the marriage officer for that purpose. The certificates must be signed by the parties and 3 witnesses. The marriage certificate is a piece of conclusive evidence that marriage has been conducted as per the rules and regulations stated in the Act. If the marriage is solemnized with formalities and duly signed, then it is valid as per section 15, which describes the validity of marriages, as it shall now be acceptable as per the law of the land. So friends, there are also certain penalties under this Act. So any person whose marriage is solemnized or deemed to have been solemnized under this Act, and who during the subsistence of this marriage contracts any other marriage in India, shall be subject to the penalties provided in section 494 and section 495 of the Indian Penal Code, and the marriage so contracted shall be void. Secondly, the provisions of subsection 1 apply to any such offence committed by any citizen of India, both within and outside India. The offence of bigamy contemplates subsequent marriage solemnized according to law, as decided in the case of B.S. Lakhande versus State of Maharashtra in 1965. It must be established that the second marriage was duly performed in accordance with essential religious rites, as decided in the case of Kanwal Ram versus HP administration in 1965. Also, there is punishment for contravention of certain other conditions for marriage, where any citizen of India who procures a marriage of himself or herself to be solemnized under this Act in contravention of the conditions specified in clause C of section 4, that is, where the bridegroom has not completed the age of 21 years and the bride is the age of 18 years at the time of marriage, or clause D of section 4, that is, the parties are not within the prohibited degrees of relationship, shall be punishable. In case of contravention of the conditions specified in clause C of section 4, simple imprisonment may extend to 15 days or a fine which may extend to 1000 rupees or both. And in case of contravention of the conditions specified in clause D of section 4, simple imprisonment may extend to 1 month or a fine which may extend to 1000 rupees or both. So to conclude with, as per section 23 of the Act, the marriages solemnized under foreign marriage laws in foreign countries will be valid and acceptable by the Indian courts under the Official Gazette. The Official Gazette is issued by the central government if satisfied with the provisions of marriage laws enforced in foreign country, and the solemnization of marriage is similar to the act enforced in the Foreign Marriage Act. There are different religions in India and many personal laws, but there is no uniform civil code for marriages yet that can be applied across the country. So this law provides convenience for the solemnization of foreign marriages. The Foreign Marriage Act was formulated with the intent to create special provisions related to marriage of Indian citizens with foreigners. But it has some flaws as well. It is dependent on the provisions of other acts. The major problem is that the act is silent in the case of divorce. Nullity or any other remedy as these provisions are not specifically stated in the Act. However, these issues have been covered so far in the Special Marriage Act. While marriages are solemnized and registered under the provisions of Foreign Marriage Act, the issue raised is that remedy or relief will be based on Special Marriage Act, and the rights of the couple will be given under the general matrimonial laws that are enforceable in the country in such marriage solemnized under the Foreign Marriage Act. The Act also fails to address the issue of succession related to matrimonial relief. The parties seeking remedies can't use any provisions related to joint family status, the inheritance rights of parties to a civil marriage, or the succession law applicable to parties and their children found specifically in Special Marriage Act. If the marriage is solemnized under the Foreign Marriage Act, then the future descendants of the parties will have to approach the court under the law of succession applicable in general cases. The penalties apply only to Indian citizens. The punishment in case of any crimes related to domestic violence or any other kind can apply only to Indian citizens. It cannot be applied to foreign parties even if they are found guilty of such crimes. There is also need to address issues related to marriage under the Foreign Marriage Act, such as abandonment of the wife for various reasons, domestic violence, instances where the NRI husband or the wife is found to be already married, continued demands for dowry, pre and post marriage, a lenient legal system abroad for grounds for divorce, etc. So with this, we come to an end of today's lecture. Thank you very much.